Everyone, my name is Hannah Townsend. I'm going to be presenting on the competence to testify. This information can be found in your Melton book from pages 161 to 162 and 177 to 189. The state is tasked with making decisions for those who cannot make decisions for themselves. This is referred to as parens patriae or state as parent. It is desired by Western society that individuals have their own autonomy. Therefore, the state is discouraged from using its parens patriae power unless an individual lacks the competence to consent to a search and seizure, the competence to exercise and waive the right to avoid self-incrimination, competence to enter a plea, competence to waive the right to an attorney and represent oneself, competence to refuse an insanity defense, and competence to testify. However, today we'll focus on competency to testify aspect. Competency to testify does not only apply to the defendant, but it applies to anyone who will testify in a proceeding, both civil and criminal. Until 1970, most states deemed children under 10 to 14 to be incompetent, meaning that any situation where a child was desired as a witness, they needed to prove the child's competence. In 1975, Rule 601 was added, which states every person is competent to be a witness unless their testimony is irrelevant or likely to mislead the fact finder, or the person is unable or unwilling to promise to testify truthfully. Most states have adopted this rule since. There are criteria from state to state, but they focused upon the ability to observe the event, the ability to remember the event, the ability to communicate the memory, the ability to tell the difference between truth and falsity, the ability to understand the obligation to tell the truth in court. It is very rare to find a witness deemed incompetent or that it coincides with Rule 403, which states that it allows the exclusion of evidence that creates unfair prejudice or confusion of the issues, will mislead the jury, or will cause undue delay, waste of time, or needless presentation of cumulative evidence. Psychological research has been conducted to assess the relevant areas which were previously mentioned, so observation, memory and suggestibility, ability to communicate, and moral development. Each category presents important considerations for competency. The research presented within the textbook covers children as they are most often to trigger competency concerns. Beginning with observation, while sophisticated conversations may confuse children, most are able to collect enough information regarding what they have seen, regardless of their understanding of it. So unless there are severe mental disabilities, hearing deficits, visual deficits, most individuals are considered to be sufficient within court. 2, memory and suggestibility. Even though children tend to have trouble remembering information over time, they are able to remember enough to provide the minimal information needed to testify. Suggestibility, however, proves different, that children are more often able to be susceptible to suggestion from a third-party information giver, such as adults, law enforcement, and such. Memory is assessed in 2 formats, recall and recognition memory. Recognition memory asks a witness if they recognize a person or place, while recall asks if a witness can describe a person, place, or event. Children tend to perform well on the recognition questions, but struggle more with recall as there's not a stimuli presented to assist in the recall. Recall can differ depending on how much time has elapsed since the event, if a third-party suggestion was given to the witness. Due to this, clinicians suggest that interviews with children happen as soon as possible to the event to provide the most accurate testimony. Ability to communicate. The competence evaluated measures an individual's maturity to communicate the event and the understanding of the relevant language to do so. If the court believes the jury or judge can understand the objective reality of the child, their cognitive immaturity is not questioned. Continuing with psychological research, we'll talk about moral development, distinguishing truth and falsity. It is noted that most courts gloss over observation, memory, and communication. A heavy emphasis is placed upon the truth-telling aspect of competence. If the individual is deemed able to relate the experience adequately, it is considered that the individual will do so truthfully. However, it should be noted that this ideology can be flawed. Courts will often ask children to define honesty, truth, or lying. While this may at times prove effective, the process alone of having a child define these terms assesses intellectual development, not the desire or ability to tell the truth. So, some general conclusions that I had drawn from this chapter. Children as young as 5 are considered to have the capacity to remember events, recall them, and communicate them, while knowing that truthfulness is important. Children as young as 3 have been noted to have sufficient capacity as well with assistance. There has been little research done to evaluate the influence of stress from the courtroom setting upon the accurate testimony given by individuals. So moving on to guidelines for evaluations, there are very few situations where a mental health professional would be necessary for discerning whether a witness would be suitable for testimony. Select situations may prove for a mental health professional, such as cases with very young children or individuals with intellectual disabilities or severe mental disorders. An evaluation of a witness would assess, and we've talked about these things before, but again, it would be the observational skills, memory, communication, understanding, and the commitment to telling the truth. Continuing on guidelines for evaluations, the best way to evaluate without potentially influencing the memory of the testimony is gathered by building rapport, asking for free narrative account, proceeding with open-ended questions that are non-leading if necessary, and only asking leading questions if absolutely necessary. If the last two steps can be avoided, they should be. Mental health professionals may be used to point out factors which would affect the witness accuracy to testify. And lastly, mental health professionals may be used to solidify a witness's testimony by improving memory performance. Some of these methods include narrative elaboration, which is to learn to organize the event into participants, settings, actions, conversations and effects, and consequences. The second being strategy training to resist misleading questions, including practice, feedback, and self monitoring. And lastly, cognitive interview, which relies on mnemonics and other cognitive interventions to enhance the ability to recall for testimony. Assessment of witness credibility. Are the statements made by the competent witness truthful? In credibility situations, it is noted that expert witness testimonies are often not admitted due to the common belief that these testimonies are opinion, not specialized knowledge. It is believed these testimonies can confuse the jury. However, Rule 608, the credibility of a witness may be attacked or supported by evidence in the form of opinion or reputation, but subject to these limitations. The evidence may refer to only to character for truthfulness or untruthfulness. And two, the evidence of truthful character is admissible only after the character of the witness for truthfulness has been attacked by opinion or reputation evidence or otherwise. And this brings the question, when are expert testimonies needed or accepted? So, continuing, an expert witness testimony has been allowed when the witness is experiencing hallucinations, rape cases where the rape may have been fabricated, situation where a child's truthfulness is being questioned, and situations where an eyewitness's testimony may have been impacted unconsciously, such as by the stress of the situation, cross racial identifiers, focus upon weapons, not faces, memory decay, gaps in memory, and the fact that no level of certainty correlates accuracy. There are legal strictures on evaluations of credibility as well. So, evaluations of parties are only allowed when there's good cause that arises for the evaluation, and this does not include the plaintiff, defendant, or someone in the custody of the plaintiff or defendant. Good cause becomes relevant when considering factors in which the witness fabricated information in the past, or more relevant, the fabrication of similar issues in the past. The privacy interest and equality interest of the victim prevents most evaluation requests unless there's impairments present to the victim which suggest fabrication has occurred. So, after everything we've discussed, you may wonder, what would an initial competency hearing look like? In the video included here, as well as in the bio of this video, you can watch as a man is questioned for his competency. The judge does ask questions to assess the competency, but it ends up being the defendant's lawyer as well that does provide some information and insight as to why they're making their request for a psychiatric evaluation. And then lastly, I want you to consider the following. Mental health professionals may be used to strengthen a witness testimony via narrative elaboration, strategy training, and cognitive interview. Why do you believe this has become such a controversial topic within the court system? The following are the references of the information I used to create this PowerPoint.